Can I just come back very briefly to make two short points on the point about why we need this information and why this appeal needs to be resolved. The first point is we know a little bit about KFW that you've seen in the board minutes. We don't know, however, about IKB's involvement. And that's important because IKB brought a claim against Credit Suisse in New York in 2011, a very similar claim. That's referenced in the amended defence at paragraph 105, sub 5. That's page 277 of the core bundle. That's the first point. And the second point is this. We need this issue resolved because it is going to come up at trial. It's going to come up in cross-examination, and it would be very unsatisfactory not to have resolved what the answer to the issue is on this appeal.
Do you know yet who the witnesses will be called on the Loreley side?
I will have to ask Mr. Chair because I'm not appearing at the trial. No.
So it may not come up in cross-examination if they don't call the people who would be asked those questions.
Well, that is a possibility.
Yeah.
I think it's unlikely. Can I then move then? I said I would set out what the structure of my submissions would be. I'd like to address the court, if I may, in three broad areas. First, that Loreley's submissions are heretical. They are contrary to well-established principles of legal professional privilege in three key respects, the most fundamental of which is that there is no evidence to support the claim. The second area, I wanted to discuss and take you to some of the client identity cases. Now, I had written here that Loreley's attempt to brush aside these cases which support Credit Suisse's position are contrary, sorry, I'll start again. I was going to say that Loreley 30's attempt to brush those cases aside is unconvincing. They had said in their skeleton, well, they still say in their skeleton at paragraph 39, it might at first blush be thought that this line of authority throws some light on the issue which arises on this appeal. Properly analysed, these cases do not do so. They deal with different questions in a different legal context. Now, I want to show you why they are relevant, but in the light of my learned...
Which cases are you talking about? I'm sorry.
Sorry, the client identity cases.
Client identity cases.
Yes, so the line with ex parte Rogers, SRJ, Ablyazov. My learned friend's position below and in his skeleton is you don't need to be concerned with those because they deal with legal advice privilege. This morning, my learned friend is positively relying on Ablyazov and SRJ. So we say the same analysis applies in determining whether contact details or contact arrangements are privileged, whether you're considering legal advice privilege or litigation privilege. Now, it may be that, given my learned friend now relies on what is said in Ablyazov and SRJ, he doesn't dispute that the analysis is the same. That's the second area, and I may be able to deal with that more quickly as a result. The third area will be addressing the implications of Loreley's proposition, which we say gives rise to some very problematical consequences, both legal and practical. The legal consequence, which is problematic, is that Loreley is forced to adopt a completely different treatment of the identity of those authorised to communicate with the lawyer in the litigation privilege context to that which applies in the legal advice privilege context. They basically say, well, you need to give that identity special protection in the litigation context. And we say that is obviously wrong when you read particularly Three Rivers 6. There are also some practical consequences which we say are frankly absurd if my learned friend is right. So, for example, one of those being that in order to claim legal advice privilege, you'd have instances where you would have to waive litigation privilege. So that's the plan. Can I turn then to my first area, that Loreley's submissions are contrary to well-established principles of the law on legal professional privilege. And the three areas are this. They overlook what legal professional privilege actually protects, that is, communications and secondary evidence of privileged communications. Secondly, they attempt to sidestep the tests for litigation privilege. And thirdly, they ignore the requirement that a claim to privilege needs to be evidenced. And I'd like to deal, if I may, with the last of those failings first, because it in fact provides the shortcut as to why this appeal should be dismissed. So the law on claiming privilege in terms of what you need to put forward as evidence, it is axiomatic that where a challenge to privilege is made, evidence will need to be adduced to make good the claim to privilege. And that evidential requirement applies just as much to litigation privilege as it does to legal advice privilege. And there's very well established case law, which I'm sure you're familiar with, as to what that evidence will be expected to contain. We will, I think, all be familiar with the canonical statement of Mr. Justice Beatson in the West London pipeline case, which has been quoted in many decisions since. I think the best place to find it and the synthesis of all the authorities is in Starbev, a decision of Mr. Justice Chamberlain at tab 22 of the authorities.
What's it called?
It is on page 492, so I think for the multiple roll that will be 496. And the relevant paragraphs are at paragraph 11 of the judgment, paragraph 494 of the on the right-hand side. So there are a number of points that Mr. Justice Chamberlain sets out here. The first being the burden of proof is on the party claiming privilege to establish it. And there he cites West London. Point 2, an assertion of privilege and a statement of the purpose of the communication over which privilege is claimed in a witness statement are not determinative and are evidence of a fact which may require to be independently proved. The court will scrutinise carefully how the claimed privilege is made out, and the witness statements should be as specific as possible. Then he goes on in paragraphs 3 and 4 to talk about the evidential requirement in the litigation privilege context, specifically about the need to address both limbs of the test, both the anticipation of litigation and dominant purpose. And then in paragraph 12, he talks about, again, subjecting the evidence to anxious scrutiny, and in particular because of the difficulties in going behind that evidence. And then, just to be fair, I think, to my learned friend, just reading to the bottom of that paragraph, I think he relies on the dictum of Mr. Justice Beatson in West London Pipeline, saying that it is desirable that the party claiming such privilege should refer to such contemporary material as it's possible to do without making disclosure of the very matters that the claim for privilege is designed to protect. The only other point I wanted to add on the law, we don't need to go to it, but you have Westminster and Dornoch in the authorities bundle at tab 19, which confirms that where you have a claim for litigation privilege, ideally the deponent should be the...
Sorry to interrupt you. It might be relevant before we leave Starbev,
yes.
But paragraph 13 in the quote at B
yes.
Recognises that it will be normal for evidence claiming privilege to be given by the person who or entity which directed the creation or communicate of the communications over which privilege is claimed, which might be an abnormal thing if the identity of that person were itself privileged.
Yes, my lord's ahead of me, because I was going to say it's sort of connected to the Dornoch point I was going to come to, which is that where you're making a claim for litigation privilege, the ideal is that you do have the evidence from the author of the communication or the person who commissioned it. And Dornoch, you see that at paragraph 21, I beg your pardon, makes that point. This basic principle about the need to evidence a privilege claim is evident in the cases dealing with the privileged status of client identity that my learned friend's already taken you to some of those cases that I'll come to. And as my Lord or Justice Mells observed, in any of those cases, where the identity of individuals or contact details were found to be protected by privilege, that is, in Abliazev, in SRJ, that finding was made on the basis of evidence that was put before the court. With that, can we look then at what Loreley's, if I put it in inverted commas, evidence says in this case? It's a witness statement, but it isn't actually evidence. You'll find that in the supplemental bundle. You've already been, I think, to look at Mr. Hibbert's witness statement so far as the redaction were concerned. You'll find his statement in tab 13 of the supplemental, page 230. And the relevant paragraph dealing with this point is paragraph 20, page 234. And he refers to the request for information and the fact that, well, he refers to the application being made by Credit Suisse for a declaration about the names of the individuals not being subject to legal professional privilege and a response to request 17 of the request. And he says this at paragraph 20, the first two heads of relief are linked, and they are both matters of essentially pure legal argument. As Loreley 30's position has already been fully set out in RPC's letter of 4th of June 2021, Credit Suisse knows what case it has to meet. I do not deal with it further. If it's helpful and you'd like to see what RPC said in their 4th of June letter, you can find that at page 185 of this bundle.
Sorry, I don't understand what evidence you're talking about, really. The evidence can only be related to a document for which privilege is claimed. And this is some sort of speculative request for information unrelated to a document. That's pretty unsatisfactory, isn't it?
Well, my lord, we already...
I mean, if you had said, tell me who is mentioned in redaction 6, then they would have to have given evidence that if they told you who was made in redaction 6, it would give you privileged information about the relationship between IKB and the solicitors, say. But you haven't done that. You've just asked for a general question, so you can't really criticise the evidence. They haven't given any evidence because you've made it so general that you've turned it into a legal point.
Well, my lord, they are claiming that redaction we looked at before the adjournment on that part of the engagement letter, and they need to justify...
Well, you haven't asked them to justify it. Where's your request to justify that redaction?
I think that is a part of the application.
Where?
So the application was seeking a declaration, seeking a response, and challenging the redactions.
Okay, where's the application, please?
So the application is at tab 10 of the supplemental bundle. And you will see on the application notice...
Which page are you?
Sorry, page 90.
90.
90. So you see on the first page in the short reasons why the order is sought, because...
Sorry, I've got something called the Defendants' Responses to the Claimant's Third Request for Further Information.
I think it may be 92 in your bundle, my lord. I'm sorry. I don't know how they've been done, but I think maybe it's 2 pages out.
Right, the application notice starts on 92. Intend to apply for an order. The names of individuals who've been authorised to give instructions. Full response to request 17. Copies of the documents disclosed. Where does it say?
3. Provide copies of the documents without the redactions marked.
Okay.
And then because, and then amongst the reasons, the claimant hasn't discharged the burden on it to establish that the disputed redactions have been applied.
Well, where's the order that the judge made. Did he order that?
Yes. So the order is that page, is in the core bundle. Is at tab 4, page 66. I don't know if that's...
Core 66.
Yes. So 66, if you turn over to the next page, it's paragraph 3, 1, by 4 p.m.
Yes.
Shall provide for the defendant's inspection a copy of the engagement letter from RPC for the claimant dated 12th of November with the redaction numbered 6 removed.
That's the only one. Which page? Remind me which page the letter is again with redaction, where redaction 6 is.
Yes, my lord. There's also reference in the paragraph below that to the redaction numbered 1, which my lady pointed out earlier before the short adjournment. It's also concerned with the identity.
In my bundle, it's 237, the redaction 6 points. So in my Lord Marston's bundle, a few pages.
So the actual, is my lord looking for the engagement letter? Yes, 191, it may be 193 of your bundle, of the supplemental bundle.
So that the engagement letter, what they want to do is to redact redaction 6, next steps and reporting arrangements. Is that it?
Yes, and as explained in Mr. Hibbert's witness statement, the basis for that redaction is that it reveals information about those who are instructing.
Where's that?
That's in Mr. Hibbert's witness statement. Well, 239, I think, of your lordship's version.
Right. Okay. So he says. It's a section headed Next Steps and Reporting Arrangements made on the basis that it sets out information concerning the identity of persons and is therefore redacted on the grounds of litigation privilege. So it does give evidence. That is real evidence. It says it's redacted because it sets out information concerning the identity of persons giving instructions on behalf of L30. So that properly stages the debate. But why are you complaining about there being no evidence? Because all he needs to say is this gives this gives an identity of people giving instructions, and I say that is privileged, and your argument is it's not.
Well, my lord, we say that that isn't evidence. If he's saying it's betraying something about, and he does say that in the 4th of June letter.
He's not saying to the court, I can say any more. All he's saying is this redaction gives the name of people giving instructions as a matter of law that is privileged. If he's right, he's right. If he's wrong, he's wrong.
Well, can I put it this way? My lord may not like me to say there is no evidence. I say it's no evidence, but it's completely inadequate evidence in that
Well, it's not inadequate. It's not relevant. I mean, he is raising a stark legal point, and I criticised him for saying it was an interrogatory and all that, all of which everybody's ignored. But as an interrogatory, it would not be a satisfactory question. But it turns out that it is a satisfactory question because the judge ordered that he uncover that redaction. His evidence is, I'm not telling you any more than it contains evidence of who gave instructions, and I say, as a matter of law, that is privileged. So the fact that there's no evidence doesn't really go one way or the other.
Well,
I mean, you may say, unless you can go further and say, if I told you the name of who gave instructions, it would disclose further information about the privilege, about a privileged document or a privileged communication. Fine, that would be another point, but that's not the way he puts it.
Well, my lord, that is exactly what I do say, that if it is indeed the case that the identity reveals something, then the evidence needs to go further and explain that is why he's not in a position to say that. But he doesn't say that. He says nothing at all. He says simply it's a matter for legal argument. And that's my submission. It is very important. Not only is there no evidence other than this, what we would say is just a conclusory statement as to why the identity is privileged, simply saying, well, identity is covered by litigation privilege. We say that's just an assertion, that doesn't constitute evidence. He's not explaining properly why it is privileged, and he's also not giving any evidence as to say why it isn't. He can't say more. I think that is what my learned friend is saying, is that he can't say more because it'll reveal the very thing which he needs to protect. But it is very important, we say, that in this case, Mr. Hibbert of RPC has not said, I'm unable to say anything more in this case because I can't find a way of explaining to you why it would give clues without revealing the very thing in issue. Doesn't go into that at all. He says, no, I don't need it to deal with evidence. My learned friend says here, we can just deal with it as a matter of general principle. So we can just say that as a matter of general principle, revealing the identity of those authorised to communicate with the lawyers might reveal something, and that justifies the blanket rule. So they've taken a decision not to give a full explanation, simply to give that one-line answer. Well,
I mean, I think you're, if I may say so, slightly labouring this point. Obviously, the bit that's redacted says Mr. Jones and Mr. Smith can give instructions on behalf of L30, right? Fine. You want to know who Mr. Jones and Mr. Smith is. If you're right that his legal point, that those names are always automatically privileged, is wrong, you win. You don't need that he needs to give more information, because if he had given more information, we would have to evaluate it, but he hasn't. So,
well, I think, my lord, if I may, the point goes a little further than this. There's an important consequence of the fact that my learned friend his solicitor hasn't put in evidence of that sort to say, well, I can't tell you because if I told you, his title would reveal something. The fact that he hasn't done that, we say, is itself revealing and allows the court to draw some conclusions that, in fact, in this case, revealing those identities would tell one nothing. And, my lord, you are assisted by what Mr. Justice Hildyard said in the RBS rights issue litigation. That's at Authorities, tab 24. We don't need to turn it up. But you'll see it, paragraph 123 of that decision. He says, the court, in assessing the claim, is entitled and obliged to scrutinise the evidence, not least as to what it does not say, as well as what it does. So we say the very fact that my learned friend is taking this general point of principle indicates to the court that actually this is not a case where Loreley are not able to tell you why it is they can't say more. Can I just expand on two further points in relation to this lack of evidence? First of all, we don't accept that putting in evidence to make good their claim would inevitably involve revealing the very privilege that Loreley seek to protect. And we say they could have done more. They could have said something in a way which would not have involved revealing the content of any privileged communication. Your Lordships will be aware that my learned friend has relied on two examples in his skeleton about how giving this sort of information might reveal something. And I'm going to come back to his hypothetical examples, but we had, on the one hand, the 5 people authorised to give instructions, someone in the finance, with 4 in the finance team. And his other hypothetical example is the head of litigation settlement. And I want to come back as to whether those are plausible examples and whether they would anyway reveal anything. But let's proceed on the basis that they would. It isn't difficult to formulate some sort of evidence which could have been adduced here to explain why the identity would have revealed something. So under the first example, Mr. Hibbert could have said, Well, there are a number of people who are authorised to give instructions. If the names of those individuals were provided, it would be possible for the other side to look them up and identify which part of the business they worked, and information about how those people give instructions and in which part of business they work would in this case reveal something about Loreley's litigation strategy. Or under the second example of the head of litigation settlement, Mr. Hibbert could have said, I can't give you that information because the person who gives instructions has a very unusual job title which would indicate something very important about the strategy in this case. Now, neither of those explanations, my lord, reveal anything privileged. So it's not right for Loreley 30 to say it's impossible for a party to ever adduce evidence explaining why the identity would give clues to privileged material. That's the first point. The second I wanted to make about the evidence, my learned friend relies on another related but different reason as to why Loreley cannot be expected to put in evidence, and this is his bright line argument. And that's, he says, well, there isn't a bright line between the identity of the party giving instructions and the content of the privileged communications. He says that disclosing the identity of those communicating with RPC would inexorably lead to the disclosing of the content of privileged communications. And he says specifically in the context of the Section 32 an attribution argument, they would need to qualify their answers. They would need to say, yes, but. And by reason of that qualification, that would follow, you would get disclosure of the content of privileged communications. But that elides two very distinct issues. Issue one, which is the question of whether the identity of those authorised to communicate is privileged, and issue two, the evidence which Loreley may wish to lead on the issue of attribution in the context of the Section 32 argument. We are simply concerned with the first of those issues. The only information which Loreley 30 has been ordered to provide, or has been the basis on which it's been asked to justify that redaction, is the identity of the persons authorised to instruct RPC. They are not under an obligation to say more. Now, if my learned friend is right, he says it's very hard to see how that would have any probative value at all, then, and he says that wouldn't assist in the Section 32 context, then of course he can make that submission at trial. Equally, Loreley may wish voluntarily to say more. They may wish to qualify the answers about who comes to giving instructions when they come to address the Section 32 case. But that is under issue 2 that I identified. That is their choice. And the fact they have to make it does not make the identity of those individuals, the issue 1 point, does not make their identity privileged. And it's worth noting that parties frequently have to make strategic decisions about how to make good a part of their case. A party may decide it will assist it to rely on some privileged material. And obviously in that situation it would need to think carefully about the consequences of any collateral waiver. Equally, a party may decide that it doesn't want to deploy privileged material, in which case no adverse inferences can be drawn. What is completely wrong is what my learned friend says in his skeleton at 43.4, where he says the very purpose of litigation privilege is to protect a party from being placed in the invidious position that it cannot respond fully and fairly to inquiries from other parties and or the court without creating a risk of being compelled to reveal privileged information. That is wrong-headed, and it is not a statement of the purpose of litigation privilege.
Okay, can I just be clear? The appeal that you're trying to meet is only of 3 parts of the order of Knowles J. First, paragraph 1, the names of the individuals who have been authorised to give instructions to RPC in relation to these proceedings are not subject to legal professional privilege. Second, by 4 p.m, the claimant shall file a full response to request 17 and 8 of the Part 18 request, and 3.1, which is that they shall unredact number 6. That's all that's appealed. And that's all you've got to meet.
Yes.
And the only one which is specific to a document and not generic is redaction 6. Correct?
That's correct, my lord.
So, I mean, I've heard what you've just said, but how can you be entitled to? I quite understand redaction 6, that is a proper claim to privilege for a part of a communication, and they are entitled to. You're entitled to ask them to unredact. But how are you entitled to make the general inquiries in 1 and 2 that you do?
Well, it's been ordered by the court in the we're back to the order of Mr. Justice Picken, which hasn't been appealed. Those were things that Loreley were required to do, was to provide a response.
So they needed to appeal that order.
They didn't appeal. They did. If had they wanted to take the point my lord is now making, they didn't.
So privilege is not an answer to it. You say.
Oh, it isn't an answer, no.
I mean, but it's not an answer anyway, because it's an order of the court requiring disclosure of information which is at large.
It was subject to the privilege exception.
Subject,
Justice Pickett did add subject to any claim for privilege for his
Well,
order.
I mean, just for the record, I still don't understand how you can have a generic claim to privilege to defend the answering of a question like this. It seems to me the argument should have been, is it relevant? And it's nothing to do with documents or communications. It's just a question.
We are where we are.
Well, I know we are where we are, but the problem is this is the Court of Appeal, and what we say has a bearing on lots of other things. So we can't just have a procedural nightmare turn into some authority that governs everybody for the rest of time without commenting on the fact that this order seems to me anyway to be pretty off beam, because it's an order that you know, if you make an order subject to privilege, you must answer this question, which has nothing to do with communications, actual communications. You're really putting the court in a very difficult position, which is where we seem to be.
Was there argument before Mr. Justice Picken about precisely what order ought to be made about these particular points? And if so, did he give a reasoned judgment? And if he did, can we see it? Or was it simply that because privilege was preserved, this point effectively went through on the nod?
It didn't go, Mr. Sher will correct me, I've only read the transcripts, it didn't go through on the nod. There was some discussion of the privilege issue between counsel and Mr. Justice Picken heard some argument and then decided it needed to go off.
But did he give a reasoned judgment as to why, apart from privilege, he was ordering this?
We'll need to... There's a transcript of the hearing. We don't think that there was a formal approved judgment. We can
Is the transcript in the bundle?
don't believe so.
I mean, I hope you understand why I'm concerned about this.
Yes, ma'am.
Let me just put it to you straight, Terence Oppenheimer. I'm concerned about it because we've been puzzling, haven't we, as to why there's no case like this. And I think the answer of why there's never been a case like this is because nobody's ever asked a generic question which raised the question of privilege. The question of privilege is only raised when X asks Y, C asks D for the disclosure of a document and of a communication, and D says it's privileged. And then there's an argument about whether it is or not.
But my lord, that does arise in the context of redaction 6. I mean, even if we didn't have the
No.
RFI.
I'm with you on redaction 6. I mean, I'm not with you. I mean, I'm just with you that that's a proper question to ask the court. But I'm very concerned about whether 1 and 2 is a proper question to ask the court.
Well,
And
I would...
on the privilege question, I mean, you were perfectly entitled, it seems to me, to go to Mr. Justice Pickin and say, I want to ask these questions under Part 18, or whatever it is nowadays. And Mr. Justice Pickin, no doubt, was entitled to order it, but he should have ordered it after hearing argument as to whether it was a proper question and deciding the question of so-called privilege. And the only way in which privilege could be relevant to that generic question is if the answer required you to disclose a privileged document, which doesn't seem to be the answer at all. Seems to be that you've got to disclose a name. Well, okay, maybe it's appropriate, but we don't know what his reasons were, so how can we decide whether he's right or wrong?
Well, my lord, but that may not be sufficient comfort. That the point I think would have reached here anyway because of the redaction point.
What, redaction 6? I mean, I very much doubt we'd all be here for redaction 6, which I suspect simply says, please refer to Mr. Jones, who's General Counsel of IKB, or Mr. Smith, who's General Counsel of the other one.
Well, that doesn't really explain then why Loreley is so keen to maintain privilege over it. They've never suggested there's a different rationale. In fact, they confirm below it was the same rationale as to the reason why they weren't responding to the request for information.
No, I mean, okay, I mean, I get all that. I mean, I'm sure there's lots of, if I may say so, tactical manoeuvring behind the scenes, but you see my overwhelming concern that once the judge has made this order, privilege ceases to be relevant. I don't understand why we're here arguing about privilege. So we ought to answer my lord's question, which is on what basis did he make the order, and what was the reservation that he made when Mr. Lord said, I don't mind you making, if this is the case, Mr. Lord said, I don't mind you making this order, provided I can still argue privilege. We need to find out what happened, because this seems to me the answer to the riddle. Why has such a case never come before the court?
Would it help to go back again to the Pickin order? I know we don't have a judgment, but
No, let's look at the Pickin order. Where is it?
it is supplemental bundle, tab 7, page 78, the relevant bit on 78. I don't know if my lord will be page 80 maybe.
Paragraph 2 and 3 deal with the documents, and paragraph 6 and 7 with the request for information.
Yeah.
So I suppose the answer is, if the claimant seeks to claim privilege in relation, this is para 7, in relation to all or any of the matters, privilege is not a matter. You don't have privilege in relation to a matter. Full and proper particulars of all matters relied upon are to be given. So that seems to be an error of reasoning. Did the parties agree to this order, or is it a consent order? What is it?
It wasn't by consent. I don't know how.
It wasn't by consent.
Well, the order recites that there was a hearing in public at which leading counsel on both sides attended.
I don't know what the process was to agree the order following the hearing. I understand that Loreley opposed the making of this order, and this was the result.
Who attended this hearing?
I think my own friend was there. Mr. Shah was there with Mr. Mitchell.
No, if I can have, I don't remember. It was a case management conference. I think it was done remotely, in the way. My memory, I'll stand to be corrected. I'll look at the transcript. My memory, it had that rather kind of roughy-tufty element that sometimes CMCs have.
The cut and thrust of the commercial court.
Shall we say it wasn't quite as clinical and linear and organised as perhaps some hearings might be? It had a bit of give and take, shall we say, and the things sort of waxed and waned, went round the place, all remotely. My memory, it wasn't the most satisfactory occasion, but the usual sort of pushing and shoving and desire to move things on in all quarters. I don't remember if there was a formal application by the bank for this. There may have been, I don't remember. I don't remember if it was something that was floated, either in skeletons or in submission, as things that should happen. I can't remember if any judge pressed us to agree this and said, well, you make this order but put privilege as a sort of caveat. I can't remember. That's what I honestly can't remember. But it happened very much in a sort of extempore way, not sort of set up with lots of memory, submission, and certainly not a reasoned judgment. But I would check. I did checks in those building blocks. I really can't remember.
Leading counsel for both sides was there, as it says so.
We certainly objected to the order. I think we objected to the order being made. We were on the wrong side of that. I can't remember whether Mr. Speaker said, well, I'm minded to make it and let you have privilege. I can't remember where it goes. But as your Lordship knows in those hearings, the court wants to move on. The court is pressing people to move on. We didn't consent to it, but I can't remember how the actual application, as it were, emerged. And that is important.
Mr. Justice Bryan had made an order at the first CMC. Is that relevant? Or was that agreed, or what?
I think it wasn't relevant to this issue. I do recall, because I've read the transcript of the hearing before Mr. Justice Pickin, that there was discussion about the fact that Loreley had put in no evidence in support for its claim for privilege. Mr. Justice Pickin said they needed to go away and provide evidence. Right. But I wonder whether some of the difficulty of this arises from the fact that, or I hasten to suggest that the difficulty might be because there's no reference to a communication. My Lord said something about that. And that may be because the normal answer you would expect in response to a please tell us, please give us the names of these individuals, if it were properly privileged, would be for Loreley to say, we can't provide that information because it would betray the contents of a privileged communication. And that's the doctrine of secondary evidence that I want to come to in a moment. There's actually nothing very difficult conceptually about the idea that privilege can protect, as we know, an oral communication. There may not necessarily be a document. And I think maybe some of the difficulty arises from that we've never had a statement from Loreley that says there is a communication in which the identity of these individuals appear, but we can't provide that because to do so would end up revealing...
You must have had, because the paragraph 2 of the order says you've got to disclose and allow inspection of all engagement letters between all those named people concerning the present litigation. I mean, that's an unusual order in itself. There must have been some evidence before the court that such things existed. And all minutes of board or similar meetings in which they decided to launch the present litigation. So again, there must have been some evidence that there was such a thing, or an affidavit, a statement saying disclosure of this is necessary for some issue in the case. And there's the request 17.
Can I just the one thing I think that you do see from the order, Mr. Justice Pickett, and one has to remember that it was a case management conference, the second one. It was before the one at which disclosure was debated. It's important to remember that it was a sort of, if you like, an extra CMC that was brought in. And there's not a reference in the recitals to any application notice. And I can't now remember. And of course, this was a CMC before disclosure had been debated with lists and the pilot being done. It was before that thing. From memory, it had come in at an earlier point.
I'm not sure that's right, because the paragraph 1 of the order is in the heading disclosure, and it says further specific provisions for issues for disclosure 11:15 to 17. Now the issues for disclosure are within the pilot, and then it says paragraph, because that's what the pilot provides, and then paragraph 7 of the first CMC order is to be amended to add a whole load of categories of extra material. There must have been a statement saying we need this extra material.
Yes, there must have been. There must have been. I can't remember the order. There's something about the disclosure and the sequence. I'm afraid I should be able to recollect, but I can't. I'm afraid.
I've just been shown the transcript. There was an application before the court at the CMC for further information and for disclosure.
Right.
Well, may I move on? I don't think I'm going to be able to assist you much more.
Okay, but can we please see the application that was before the court and also the transcript of Mr. Justice Pickens' hearing?
We'll make sure those are available.
Yeah.
Just before we conclude with the bright line, my learned friend's bright line argument, it's also important to note that this is in tension with his main argument on the appeal, that the identity of those instructing of itself would reveal something or give a clue about strategy. Yet the whole point of his bright line argument is that actually the names alone wouldn't divulge anything. You'd only get something divulged by the qualification. So the bright line argument proceeds on the basis that the privileged material would not be revealed by the names themselves, but by the extra information that Loreley would apparently need to add. And we say the fact that Loreley are even advancing that argument demonstrates the fallacy of the primary position that the name or names of the persons instructing RPC would alone reveal a privileged communication or some aspect of Loreley 30's litigation strategy or preparation. Can I just do one final point on evidence?
You say the bright line argument is fatally flawed because the privilege doesn't attach to people's names. Privilege attaches to communications, full stop. So unless you're talking about a communication by such a person, there's no question. And then you say, if we're talking about one like a board minute, which reveals discussions, which is a communication in the presence of lawyers, then you have to say why the revelation of the name would give privileged information.
Indeed, my lord. I'd only just clarify that to say my point about privilege applying to communications should not be taken as a hard and fast rule. I accept that privilege may attach not to the identity of those instructing, may attach to the identity of a witness, and we'll come to that. It's not as simple.
Not in itself.
It may in itself because of what it reveals. That's the point I want to come to about secondary evidence.
Well, I think it's a shorthand, Ms. Oppenheimer. I think the problem with those cases is they're talking about a shorthand. If you look at Three Rivers and ENRC, it's perfectly clear from Lord Carswell and even what I said that privilege attaches to communications, full stop.
My lord, I'm completely with you on that, and that is part of my submissions. But there are cases. It is also the case that it is not as simple to say legal professional privilege applies to communications full stop, because we know that there are certain exceptions. For example, secondary evidence. And perhaps it's useful if we now turn to that, my lord.
This is what you call the secondary evidence exception.
Well, I wouldn't even put it as an exception. It's legal professional privilege protects at its highest level communications, not facts, as my lord found in ENRC. And the whole concept of legal professional privilege is built around the concept of communications. My learned friend mischaracterises how I put it below, and I was keen to, if I might qualify what my lord was putting to me was my submissions just now, in that we don't say there is a rigid rule that privilege attaches only ever to communications, full stop. We don't say there's such an absolute rule. We acknowledge that there are exceptions. The point is a more subtle one, that yes, privilege protects communications is the guiding principle, and that's how you understand how privilege works and is applied. But there are cases of material and information which nevertheless has been found to be subject to legal professional privilege, even though it is not itself a communication. And that's what I'm putting under the heading secondary evidence of privileged communications. So that is a document or material which records or summarises or reveals the substance of the privileged communication. I think it's going to be easiest if we go to some of the law on this. And my lords, this is...
I agree. I mean, of course that's the case.
Yeah.
A document which records a privileged communication, say orally, is subject to privilege. I mean, it can hardly be contested. I see Mr. Law nodding vigorously. Of course it's the case. But how does that help when you ask a question like, who gave instructions to your lawyers? And you're saying that the answer to that question is privileged.
The reason it helps, my lord, is because it helps, A, to analyse what the judge was doing here when, I know you don't like his two-stage test, but when he talked about the concept of undermining the privilege, it's, we say, akin to what you see in some of the other cases where they talk about documents or material revealing or betraying the content of privileged communications. So it's an important concept to be able to understand, first of all, what the judge found in this case, to understand what was going on in some of the client identity cases, and indeed in the cases about why witness identity is privileged, because we say that is an example of the secondary evidence rule. My lord, it may be that my learned friend says, well, that's all, we accept all of that, but strangely, he doesn't accept the principle of secondary evidence when it comes to examining the very question that is before the court. And we say, you apply exactly the same principles. You say, is it a privileged communication? Or is it somehow inextricably linked and part of the privileged communication? That may be one reason why identity may be privileged in an SRJ. It's all part and parcel. Or is it a case where that information would reveal something about the privileged communication? And if it isn't either of those things, then it's not protected by privilege. Can we go to Edwardian group, which is, I think, the most helpful case on the concept of secondary evidence, and that's in the authorities bundle, tab 25. It's page 555, so in my Lord Master of the Rolls bundle it'll be in 559. A decision of Mr. Justice Morgan. Let me just tell you what it was about. It concerned an unfair prejudice petition. The petitioners were defending a claim to privilege over certain litigation funding documents which had been withheld and some redacted. And the respondents were advancing a defence of laches. The petitioners said that there wasn't an improper delay in the bringing of their petition because they didn't have sufficient funds to bring proceedings at the time of the allegedly prejudicial conduct. And so they said their attempts, the petitioners said that their attempts to obtain funding went to that issue. Can we pick it up at paragraph 13, which is at 563 of the bundle? And you see there's a reference to the application at paragraph, sorry, wrong page number, I do apologise. 559 is the page number, paragraph 13. So there's the application of the respondent challenging the claim to privilege. And then you get a reference over the page to the responsive evidence of the petitioner, Mr. Mervis, solicitor who is defending the claim to privilege, and his witness statement is referred to there at paragraph 15, and then there's more reference to his evidence in the following paragraphs. Can I draw your attention in particular to paragraph 20 of the solicitor's evidence, and 20 sub 5, where Mr. Mervis, the solicitor, explains the approach adopted as to which documents allowed the drawing of inferences as to legal advice. He then discusses in detail the terms as to funding which might allow such inferences to be drawn, and then he refers to the various provisions in the funding agreements. You then get a long discussion in the judgment about what the correct test is for determining whether this test for secondary evidence of privileged communications has been met. And we start with the principle at the bottom of page 563, cited from 3 Rivers 5, from the judgment of Lord Justice Longmore, that privilege extends to material which evidences the substance of the communications. And then you get the rival submissions in the next few pages of the parties as to how that test works. Now, if I can just briefly summarise it, the respondent's case was that you can only, in a document from which you can only infer the substance of the communications isn't sufficient to engage the protection of privilege. The document has to do more than that. It needs to reproduce or reveal or summarise or paraphrase. And the respondents, that was Mr. Lightman, relied on the FSCS decision of Mr. Justice David Richards and the decision in the Good Luck. The petitioners, you can then turn to paragraph 32. Mr. Fenwick was acting for the petitioners. They argued for a broader test, and they said that privilege will be engaged where a document gives a clue to the advice being given. And there they rely on the Lyle and Kennedy decision and Venturis and Mountain decision of Lord Justice Bingham. Ultimately, the judge then also goes on, incidentally, to look at some Australian decisions over the page at 36. Ultimately, the judge sides with the petitioners, and he says that the relevant test is the one set out in Lyle and Venturis and Mountain. And he also then brings in...
Which paragraph?
That's paragraph 37.
37.
37, yes. And he concludes with a distinction in the Australian case of AWB and Terence Cole at the bottom of that paragraph. And he says he would adopt the distinction used there between a case where there's a definite and reasonable foundation in the contents of the document for the suggested inferences to the substance of the legal advice given, and merely something which would allow one to wonder or speculate whether legal advice had been obtained. Now, for our purposes, the precise boundaries of the test aren't important. But what is significant is that the court is bound to assess the evidence on privilege against that test. And that is what Mr. Justice Morgan then does in the subsequent paragraphs. And he finally concludes, you see at paragraph 43, he says he's not entirely satisfied with what Mr. Mervis has done. He has some doubts about the way in which he's applied the test, but he's not able to conclude that Mr. Mervis, that it's reasonably certain that he hadn't applied the test correctly, and on that basis he doesn't feel he can go behind it. So there we have it. There's the classic statement of what you do when you're claiming privilege over a document on the basis that it reveals something about a privileged communication. And I won't take you to it, but the decision of RBS rights issue litigation, Mr. Justice Hildyard, is an example. That's in Authorities tab 24. That is an example where the judge found that the evidence that was put forward in that case by RBS didn't satisfy the test of giving a clue to the legal advice that was offered. In that case, RBS were claiming privilege over certain interview notes, and one of the bases on which they claimed privilege was that they said that those interview notes constituted lawyers' working papers. My Lord Master of Rolls may remember we raised this issue again in the ENRC, but anyway, that was undecided. But the point in RBS was that Mr. Justice Hildyard said that the evidence that had been offered by RBS was inadequate. He said it was, you can find this at paragraph 125 of the judgment, only conclusory assertion was offered, and the evidence doesn't go beyond the train of inquiry, and doesn't establish that the disclosure would give a clue about the trend of advice.
But how does it help you to say that you can have privilege in a document that gives a clue to legal advice, and therefore you're entitled to ask the question, that the question of privilege is relevant to the question you're seeking to ask here, which is the interrogatory. I mean, it's very interesting, of course, if you seek to maintain privilege for a document that gives a clue as to which witnesses you're going to be calling or which documents you've been collecting in Lyle and Kennedy for the case from third parties. Fine, I mean, of course it gives a clue, and it may be privileged. But that's miles away from the argument here.
Well, I'll go, if I may, now to a litigation privilege decision, but my lord, I would suggest it isn't. The same principles apply. This was information that was relevant to Credit Suisse's case that they asked. They were told on being asked, can you please provide it? No, you can't have it because it's privileged, and they're entitled to test that claim to privilege. As any litigant who's told by another party, no, you're not entitled to that, it's privileged. You say, well, fine, explain to me why it is, and give me some evidence as to why it is.
Well, I mean, that's just begs the question, because it says they're entitled to say information is privileged. And you're not just entitled to say information is privileged unless you can say that there is a privileged communication which this information discloses.
I'm afraid I don't follow my lord's point.
But I mean, the information in the ether does not attract privilege. The only reason information attracts privilege is because what is protected is a communication between the client and the lawyer. And if there is a document that is a secondary document that gives a clue as to the privileged communication, in other words, something seeking or obtaining legal advice or giving tactics about litigation, yeah, it would be privileged. But it's not just generic. You can't say, they can't say, I'm not answering this question. I mean, let's say you'd asked who runs IKB, right? They can't say that's privileged, it's a fact.
I'm not.
I mean, it's just not a relevant answer. And I don't see that this question has got anything to do with privilege. I mean, you might say they're not entitled to it. I mean, he might say they weren't entitled to ask that. You weren't entitled to ask this question.
My lord, that is the basis on which they're telling us we can't have the information. So that is the basis on which Credit Suisse has brought this challenge.
Mm. There's a more simple answer to it, I would have thought, which is it's not a question of privilege, who gave instructions. Not unless there's a document or a communication that is relevant, like redaction 6.
Well, that may indeed be a problem more for my learned friend, that he can't reveal a communication that is.
Well, it may well be, but I mean that's why this case has got off to such a strange start, and that's why I find it very difficult being asked in the Court of Appeal to decide whether a question about who gave instructions to solicitors is always privileged. The answer is I've no idea. Maybe. Just depends on what document you're talking about, what instruction you're talking about.
Well, my lord, in my submission, that is what the judge found, and what is the correct position. It depends, and it depends what evidence might be put forward as to why that might reveal something in a particular case, and it all points to the fact that there is no justification whatsoever for having a general principle. My lord, just continue briefly on this same topic, see if I can endeavour to persuade you that both the question that was before the judge and the way that he resolved it was perfectly in accordance with orthodox principles of legal professional privilege. The WH Holdings case that my learned friend took you to briefly,
I mean, there is a tension, isn't there, in the judge's order, because on the one hand, he made a general declaration that the identities of the individuals giving instructions was not privileged, but on the other hand, in respect of all the redactions other than redaction 6, he sent the claimants away to look at the documents again, whereas his general declaration would seem to say that there was nothing particular to look for. Or have I misunderstood that?
yes, I think it might have been better had 3.1 appeared in paragraph 1. I think he treated that redaction, as my learned friends did below, as covering the same point, and then the other redactions were concerned with other points.
Well, you say that, but it doesn't look like it from the letter.
Well, some of them, my lord, were to do with legal advice privilege, which they said, we basically want to have an opportunity to come back and justify the claim for legal advice privilege, because if we're right, if we're wrong, and we therefore then we accept we're going to have to identify those individuals for our legal advice privilege claim. They wanted to be able to come back and improve upon their claims for legal advice privilege. And do it in a two-stage process. We invited the judge that it all needs to be dealt with in one, but effectively he's given them an opportunity to come back and have another go at their legal advice privilege claim, depending on the outcome of this appeal. My lord, can I just take you briefly back to the E20 case, which my learned friend took you to at tab 28 of the authorities bundle. And this is to make good the proposition, maybe I don't need to, but lest there should be any doubt about it, that this principle of secondary evidence and the evidential requirement needed to make good a claim for secondary evidence applies as much to litigation privilege as it does to legal advice privilege. And you'll see that as if you go to the authorities at tab 28, page 654 for the beginning of the decision, but at paragraph 20 of the judgment of Master of the Rolls, page 661, we would accept that a document in which advice or information obtained for the sole or dominant purpose of conducting litigation cannot be disentangled, or a document which would otherwise reveal the nature of such advice. And then it says or litigation, but we think that must be a misprint for information in the way that advice or information appears in line 1, would itself be covered by litigation privilege. And you see the same principle referred to again at 27 sub 4 of the judgment, where the Master of the Rolls sets out their conclusions. Sorry, it's a joint judgment of the court, I do apologise. The conclusion number 4, documents in which such information or advice cannot be disentangled or which would otherwise reveal such information or advice are covered by privilege. So the secondary evidence rule applies to litigation privilege and legal advice privilege. They obviously may reveal different things depending on which limb. In legal advice privilege, it's about revealing or being able to infer the substance of the underlying legal advice. And in litigation privilege, it may be about revealing the substance of the advice about the litigation or about the preparations or the strategy concerning the litigation. But in all cases, you need evidence as to why disclosing that document or material will give the necessary clues. Well, having taken you to those cases, and I take from my learned friends nodding before that there isn't any dispute about these principles, and indeed Loreley 30 in fact rely on them for some of their redactions in the engagement letter and board minutes, because they say in places that they've redacted on the basis that the section reflects the content of advice or contains information which was provided about Loreley 30's objectives in the litigation. We say it's therefore anomalous that there isn't any mention at all of these principles in Loreley 30's case on this appeal. And we say that's particularly odd because the only justification that we're given for why identity might be protected is that it might give clues to the underlying strategy. And that is the very rationale underpinning the secondary evidence doctrine. And we say it's also consistent with how the judge analysed this, the point that my lord put to me before the short adjournment about another way of how one might look at what the judge was doing. We say a way of looking at it is he was saying, is there a privileged communication or is there secondary evidence of a privileged communication? And that's what he was intending by the words undermine. So given there is already a method by which, a route by which identity of a person instructing might, in a particular case, give clues, and the route being you put in evidence to explain why that is, why does one need the absolute rule that Loreley 30 are now contending for? In fact, one can go further and make the observation that you only need a rule like that, a blanket rule, when the privileged status of the identity of the individuals cannot be justified with evidence. In other words, in those cases where the identity of those persons would in fact reveal nothing. Can I deal in this context with the identity of witnesses? And we say that is another instance of the secondary evidence principle at work. The identity of a witness is privileged because it will in almost all cases reveal a privileged communication. The very fact that a person is being spoken to as a potential witness is inherently revealing something of the party's strategy, specifically what evidence is the party seeking to adduce. And we say that is so obvious that it's not surprising that the courts haven't considered it necessary for a party to adduce evidence to that effect, that disclosing the identity would reveal something. Indeed, it's so obvious, we see the identity of witnesses mentioned in the seminal case authority on litigation privilege in War and British Railways Board. Would you mind just turning that up at tab 4? It's in the speech of Lord Wilberforce, page 43, is the beginning of the judgment, and then the passage I would like to go to is 531b, which is page 53, I think for my Lord the Master of Rolls might be page 57. You'll see about a quarter of the way down. My Lords, before I consider the authorities, I think it desirable to attempt to discern the reason why what is inaccurately called legal professional privilege exists. It is sometimes ascribed to the exigencies of the adversary system of litigation, under which a litigant is entitled within limits to refuse to disclose the nature of his case until the trial. Thus, one side may not ask to see the proofs of the other side's witnesses, or the opponent's brief, or even know what witnesses will be called. So it was obvious there to Lord Wilberforce. Can I take you to one other decision on the identity of witnesses, which is that authorities...
That's nothing to do with privilege, is it? And anyway, it's not the law these days.
Sorry, my lord.
That's nothing to do with privilege, necessarily. And anyway, these days you do find out which witnesses are going to be called.
Well, you obviously find out at which point the person decides, and that's a point that's made in the text, that it's not, their identity doesn't remain privileged for all times, obviously, because at the point at which a party decides. But until that point, their identity is privileged.
But that just, I think it's loose language. I'm sorry to say this of Lord Wilberforce. I mean, litigation was completely different in that era. And if you look at what Lord Justice Morit said in China, which is closer to your point, and you know, you can justly rely on it. At paragraph 45, he says both the information, sorry, this is at page 185, both the information given and the identity of the person supplying it are confidential and privileged unless and until the privilege is waived. So he does say that it's privileged, although he might actually have said it's confidential and attracts privilege because it's part of the communication with a third party about the litigation. But
well, can I take you to one more authority which is more recent than War, and that's Kelly and Worley Magistrates Court decision of the Divisional Court. It's at tab 18, where Lord Justice Laws gave the judgment there. It's page 439 of the bundle, and you can go to page 446 at paragraph 20. The beginning of paragraph 20, Lord Justice Laws says this: he refers to ex parte Hicks is with respect no assistance in the present case, and in my judgment it is clear that litigation privilege attaches to the identity and other details of witnesses intended to be called in adversarial litigation, civil or criminal, whether or not their identity is the fruit of legal advice. And if you just drop down to the bottom of that paragraph, the rationale, we say, is apparent here. This cannot, in my judgment of itself, extract the litigant's historic right not to disclose his case until he presents it from the categories of protection, LP, and where it applies, LPP, where in principle it belongs. And then finally, in this same case, can we look forward to paragraph 22? He talks about, here I think LPP is being referred to here as meaning legal advice.
He says why in paragraph 21. He says it falls to be regarded as the fruits of legal advice, as Mr. Lord Justice Mollett said, which is obviously normally right.
Well, he says a little bit more, my lord, if you turn to the bottom of paragraph 22 on the following page, just above the heading, proposed justifications. It says, we may with respect take it, certainly for present purposes, the imperative force of LP and LPP is in effect the same, if there were no confidentiality such as both rights protect, and every litigant were able to disclose the building blocks of his case stage by stage as they were developed, the scope for witnesses being discouraged, false points being taken, the truth being distorted would surely be very greatly increased. And we say, I don't with respect agree it's just to do with the fruits of legal advice. He's talking here about the building blocks of any litigant's case, and the building blocks will include what evidence it is deciding to call. So we say witnesses are self-evidently a building block of a case. Now, can I deal then why the identity of those communicating with the lawyers is not analogous to the situation of witnesses? There are no building blocks of a party's case, to adopt Lord Justice Law's terminology, which are revealed by disclosing the identity of those authorised to give instructions to the lawyers. And my lords, we can see that point could be made by reference to the extract from Lord Rogers' speech in 3 Rivers 6 that my learned friend took you to this morning and that he relies on in his skeleton. Lord Roger talks there about litigation being based on the contest, you'll remember, in which each of the opposing parties assembles his own body of evidence. Then he talks about that in a system, a party should be free to prepare his case as fully as possible without the risk that his opponent will be able to recover the material generated by his preparations. You say it is obvious that providing the name of a witness will reveal to the other side the fact that you have the cooperation and assistance of that witness for the purposes of the claim. You couldn't have something which is more clearly part of assembling of a party's body of evidence. It literally is the evidence. But in contrast, the identity of the individuals instructing the lawyers reveals nothing whatsoever about how the party is preparing its case, in the sense of what evidence it intends to deploy in the litigation or what advice it is getting. And that is well illustrated by the fact that Loreley has struggled to come up with examples as to how revealing that identity would disclose anything about their preparation of the case. I would like to canvass a hypothetical scenario, if I may, which I venture to suggest is a little bit more realistic than the examples Loreley has come up with. Let's suppose, hypothetically, that Loreley 30 were to disclose that the person providing instructions to RPC is the General Counsel of KFW. That would tell Credit Suisse nothing at all about the evidence that Loreley 30 is gathering. By seeking that information, Credit Suisse aren't seeking to find out anything about Loreley 30's case on limitation or indeed on anything else. Credit Suisse is not trying to take advantage of any of Loreley 30's case preparations, which is exactly what Lord Rogers' dictum in 3 Rivers 6 was driving at. Now, against me, it is said that this information would provide a relevant building block for Credit Suisse's case on limitation. In fact, my learned friend uses that very terminology of a building block in his skeleton at paragraph 45. But that is nothing to the point.
You talk about, sorry to interrupt, you talk about building blocks of the case as if that were the test, and you distinguish that from fruits of legal advice. But is that a real distinction? I mean, the building blocks of the case are essentially what the solicitor advises the client needs to be done in order to prepare the case, and then goes away and does it.
My lord, it may not be, and it's not a distinction that matters for the purposes of my argument.
It does matter, because it's critical that it is the fruits of legal advice. That's what attracts the privilege. And intellectually, you can't justify some sort of building blocks argument that is detached from legal advice. Privilege is about legal advice, preparing a case for litigation or legal advice.
Well, it may not always be about legal advice, my lord, because litigation privilege is not just about legal advice.
No, it's about legal. It is about communications with the lawyer. I mean, look at the test. We go back to the test, the 3 tests for litigation privilege. I set it out in ENRC. Everybody agrees it's the test. Let's go back to it. Where is ENRC? It's a, and you know, we can't keep on having these sort of broad brush, different legal statements which are simply removed from the underlying principle.
My lord, I subscribe to the test. My point is simply trying to explain why the position of those authorised to instruct the lawyer is not equivalent to the position of witnesses. That is the only context in which I'm dealing with this building blocks. I'm not trying to substitute what the test is for litigation privilege. I stand by what the test is for litigation privilege, and my learned friend doesn't meet it.
Right. Litigation must be in progress or in contemplation. Communications must have been made for the sole or dominant purpose of conducting the litigation, and the litigation must be adversarial, not investigative or inquisitorial. That's the test. And it's all about communications, and it's all about legal advice. If it's LAP, it's about legal advice.
My lord, it is. So my learned friend has to either satisfy you that there is such a communication, or that the information that is being sought or that is captured by that redaction, that information would reveal something about that privileged communication. That is what he needs to satisfy you of. I accept that's the test. He doesn't satisfy it. My lord, I want to deal with the point. It may not be troubling.
I mean, I know you don't want to answer this question, and I know it's very unwelcome. But there is no communication in issue when the question is asked, who gave instructions to the solicitors, unless it's who communicated in such a way on such a date with the solicitors. This is a general, generic question to which privilege does not attach. It's got nothing to do with anything, unless it's a communication. And the generic is not something that's ever come before this court because privilege is about communications. And,
Well-
and that's the problem here. And the whole thing got off to a wrong start because the parties agreed, obviously, before Mr. Justice Pickin, that this could be a proper question about privilege when it should have been attached to redaction 6 or redaction 1 or redaction 33 or some other documentation. And if we answer the question as posed on the postcard, we're going to be making difficulties for everybody, because we're going to be just like saying the building blocks of the case are protected by privilege, which is loose language and unhelpful. They probably are in 90% of cases, but you need to see why.
Well, my lord, I'm doing my best, and perhaps not completely successfully, to show why forming a structure into which all of this fits. And that's why I said at the beginning, what the judge found was, first of all, of relatively modest scope. All he said was, it's not made out in this case. I don't have any evidence before me which suggests that the identity of these individuals are privileged. They may be in another case. We know there are cases where identity of individuals has been held to be privileged. And the other thing I'm attempting to do is explain why the judge's analysis followed orthodox principles of legal professional privilege. That's why I've spent time on this doctrine of secondary evidence, because I entirely accept everything my lord says about privileges about communications. It is.
That's why that's why I have great trouble with paragraph 1 of the judge's order. The identities of the individuals who have been authorised to give instructions are not subject to professional legal privilege. Of course they're not. Why would they be?
Well, can I put it another way? That it could have been the case that, and I don't know how the disclosure precisely, how it has all arisen. We could have had a situation where lots of communications were disclosed but withheld from production on the basis of privilege. And then we would have, my lord's point about, we'd actually have some communications to grapple with. They haven't done that.
Well, we have got some. We've got one.
Paragraph 1 of the judge's order would extend to somebody who was authorised to give instructions but had never in fact done so.
Exactly. And it's a very dangerous order to make, because it's I mean, I was trying to think of an example about apples and pears and fruits, but I don't think it helps probably. I mean, it is like saying that making a declaration that something that could never possibly be the case is the case. It's a complete confusion. And this court, I mean, it's all very well for Mr. Justice Knowles in the cut and thrust of commercial litigation, where everybody's asking him to make such an order, and I'm sure the parties, sort of one party or the other was asking him to do so. But for this court to do so would put everybody for this court to uphold that order would put everybody on, I mean, the Supreme Court would say, well, that's not what privilege is about. What on earth are you talking about? And nobody wants this case, I'm sure, to go to the Supreme Court on a false basis. So we have to say whether that order can stand. Even if we only say, well, the parties can agree what they like, but this was all silly.
Well, I understand that. I don't think I can say again, and maybe it doesn't persuade my lord, that all Mr. Justice Knowles found was that the case for this identity being privileged in this case was not made out on the evidence. It doesn't need to go
That's not
further
what he
than
said
that.
in the order. So you accept that the order 1 should go?
Well, the way it's been treated is it's the flip side to what it appears in 3.1. I hear what my lord is saying, but don't see the conceptual difficulty that this has arisen by reason of a request for information. I feel that the spotlight needs to be shone on the other side of the court to say not why are you seeking this information and how is this
Well, we did that this morning. This afternoon we're shining the spotlight on you. That's our job.
My lord, the point is they've made this claim to privilege. They now need to justify it. How that has come about, my lords may think is unfortunate, but the position is a claim to privilege has been made which has been challenged. And that needs to be resolved.
Yeah, well, I mean, as regards documents, I completely agree. I mean, as regards communications, I completely agree. It has to be resolved.
Can I just, I wanted to finish, it may not be troubling your lordships and my lady, but the point that's taken against me that this would provide a relevant building block for Credit Suisse, we say is nothing to the point. Indeed, when you look more closely, that is a bizarre submission, because if the information didn't have any relevance, then it wouldn't be disclosable. Relevance is a precondition for disclosure, not a justification for privilege. And indeed, in the identity cases that we've been referring to, the Rogers and so on, the parties seeking the information wanted that information to advance their case.
Obviously, I mean, you know, obviously you've touched a nerve. Or we shouldn't be.
My lords, I'm going to deal, the last bit of this section, I'm conscious of the time, I was going to deal with the test for litigation privilege, but I think we're on common ground that we all know what the test is, and I thank my lord for quoting from ENRC. And the only point I wanted to make, the zone of privacy, as my lady observed this morning, didn't feature very much in my learned friend's submission.
Zone of privacy.
The zone of privacy, yes. And my learned friend refers to it throughout his skeleton as the rationale. At times, though, if one reads carefully, he tries to substitute it for the actual dominant purpose test.
Can you help me with something else? And that is that I noticed in the giving permission to appeal, Mr. Justice Knowles said that there were two views about this question in the textbooks. And I'm not conscious of you know, are there passages that he was shown that really show a conflict?
No, my lord, it was two separate points. I think his points were two reasons for appeal. One, the zone of privacy. The second was the point on which I lost below as to whether lawyer-client communications are protected only by legal advice privilege or whether they're also subject to litigation privilege. That was what he was referring to about the debate in the text, and that's.
And somebody, I thought that Mr. Thankey, who argued ENRC, as I remember it, says it's wrong, but I thought he'd won ENRC.
He did win ENRC. Sorry, the comment about Mr. Thankey is in relation to zone of privacy. So it's 2 points that Mr. Justice Knowles put in his reasons for permission. One was perhaps the Court of Appeal would like to examine the zone of privacy issue. Yeah. Two, perhaps they'd like to look at the point about whether lawyer-client communications can be covered by both types of privilege. Right. We didn't put in a respondent's notice.
The answer is no to both those, then.
No to the second one, because we didn't put in the respondent's notice. As to the first, Mr. Thankey, in his text, in our text, does refer to zone of privacy.
You're on that book.
I'm on that book as
well. You're on that.
I didn't write that chapter.
No. That, I'm afraid, doesn't run.
The zone of privacy is referred to in one point, and it comes from a Canadian test, a Canadian case called Blank and Canada. Can I make this point? I think it's worth making, but hopefully quickly. The zone of privacy is no more the test for litigation privilege than making a clean breast of it is the test for legal advice privilege. There isn't a single English case of which we're aware where zone of privacy is referred to as the relevant criterion or test. And as I said, it comes from this decision of Blank and Canada. But I think the reason why it would be helpful just to turn it up briefly, is that zone of privacy doesn't actually mean very much unless you ask yourself, a zone of privacy for what exactly? And that's where, when you look at that decision, you see actually it's not very different to the rationale we have in this jurisdiction anyway. You find this at towards the end of the authorities bundle, tab 34, page 847. You have the English on one side and the French on the other, if you want to look at that instead.
But in case we want to look at the French.
Yes.
I'm sure we do.
So, can we just, in this, I should just say, so the court is aware, Canadian law on privilege differs in some very important respects from English law. I can just tell you two of them. There's a suggestion in this case that litigation privilege might come to an end once litigation has ended, which is obviously not our law. And in Canada, they also have a principle that privilege is not absolute and can be set aside if there's a sufficiently compelling public interest. You see reference to that in 3 Rivers 6. So just with that word of warning, can I take you to the bits about the rationale for litigation privilege? See the main decision by Mr. Justice Le Juge Fish. And if you go to page 858, which I think in my Lord the Master of the Rolls might be 862, you see the justification here, the different rationales being given for the two limbs of privilege. And if you look at 27, you see the object is halfway down. The object is to ensure the efficacy of the adversarial process and not to promote the solicitor-client relationship. And to achieve this person, parties to litigation, represented or not, must be left to prepare their contending positions in private without adversarial interference and without fear of premature disclosure. And then Justice Fish goes on to quote from another judge, Sharp J.A. And if you look across to the following page, you will see in the second paragraph, when he talks first about the rationale for solicitor-client privilege, and then he goes on to the rationale for litigation privilege. Its purpose is not explained adequately by the protection afforded lawyer-client communications deemed necessary to allow clients to obtain legal advice, the interest protected by solicitor-client privilege. Its purpose is more particularly related to the needs of the adversarial trial process. Litigation is based upon the need for a protected area to facilitate investigation and preparation of a case for trial by the adversarial advocate. And then if you turn the page, again, 2 pages, you then get, paragraph 32, the next page, 860 in the bundle, you see the first reference to being entitled to a zone or chamber of privacy, and that's repeated again 2 paragraphs on in the left-hand column of 861. So we have this label, zone of privacy, coming after Justice Fish has explained the whole rationale being to facilitate investigation and preparation of a case for trial and having this protected area. If you move on through the judgment, you see a reference again to Justice Sharp at paragraph 40, page 862. He refers back to mention for the need for a protected area to facilitate investigation and preparation of a case for trial by the adversarial advocate. So when you consider what the purpose of the zone of privacy is, you see that the policy is about preventing the adversary from finding out about the opponent's investigation and preparation of his case for trial. And that accords with the rationale that is articulated in many of the English authorities. So the test for litigation privilege, we all know what it is. My Lord has mentioned it. ENRC, you also see it in WH Holding. And in my submission, those cases make clear, WH Holding particularly, why it is very perilous, as my Lord has already intimated, of trying to do anything but stick to the actual test. Because if you just apply zone of privacy, you're liable to get the wrong answer. If you put zone of privacy to the WH Holdings decision, remember that was about communications there discussing a commercial settlement, where the Court of Appeal said, no, those don't satisfy the test for litigation privilege. If you just simply thought zone of privacy, you would have thought that email communications with the board about a commercial proposal to settle a dispute, those would be quintessentially things to do with zone of privacy. That obviously is not the law in this country, and that shows why one should be very careful, as my lord indicated, of using anything but the well-established test. And the same point arises out of the decision of Excalibur and Texas Keystone, which I won't take you to, but is Authorities tab 21, just to tell you briefly about what that case was about. The defendants there were seeking details of the claimant's attempts to obtain litigation funding and documents going to funding that was obtained. So it was a bit similar to the re-Edwardian group. And Excalibur said, no, the documents were privileged because litigation privilege covered all documents brought into existence for the purpose of actual or contemplated litigation. Interestingly, that was a submission of Mr. Justice Pickin. Anyway, the defendants...
No, Mr. Pickin.
Sorry, Mr. Pickin at that time. The formulation, Mr. Pickin's formulation was rejected by Mr. Justice Popplewell, and he said, no, litigation privilege applies to material which is for use or potential use in the litigation, and funding documents weren't for use in the litigation, even if they had been brought into existence for the purpose of it. And you may recall Mr. Justice Popplewell gave a rather colourful illustration of why Excalibur's formulation in that case went too wide. He gave the example of a litigant buying a new suit for trial, which could be said to be for the purposes of litigation, but wasn't for the use in it. So again, we say...
Is that why Mr. Lord was so keen on buying a suit this morning?
So we say, again, Excalibur shows you why zone of privacy, very perilous to use that as the test. So, as my lord was keen to do, I come back to the test. How does the identity of those instructing fulfil the test? My learned friend doesn't actually explain in his skeleton how it is met. It's just simply asserted in his skeleton. He just says it is an aspect of the giving of instructions. In fact, there are numerous cases, those what we call the identity cases, which are inconsistent with his position. And those cases say that the identity or the contact details of those instructing will only be privileged if the identity or contact details are communicated as part of a privileged communication or where they are wrapped up with the content of the privileged communications, as in SRJ or Ablyazov. Now, the closest my learned friend gets to trying to justify why the identity is protected is his footnote about those examples of how the identity of the person might give clues. And if I may, I'd just like to turn to those briefly now. We say those examples are politely far-fetched. The first one is the 5 people are authorised to give instructions. Of those, 4 work in a team focused on financial valuation analysis. This may indicate that the company's energies are being devoted to the quantum side rather than the liability side of the dispute. There are several responses to this. First, even if, contrary to an arrangement I've ever seen, the client did have some sort of division like that, how would it become apparent to the opposing party by the identification of the names of the individuals? Second, even if one could assume in Loreley's favour that a party could identify from the list of names that particular individuals were working in particular departments, what privileged material would that actually reveal? The notion that you could say because 4 or 5 names are in the finance team, that means quantum is being prioritised, is, we say, tenuous in the extreme. It tells you nothing about how often the communications are happening, who has more responsibility. How could you infer anything about importance or strategy from the mere number or names of people authorised to give instructions? And one can think of all sorts of explanations for why there might be 4 people working in one area. They might be part-time, it might be more technical, expert evidence might require more time. So we say this is really the point which Loreley make about their bright line rule. They say, I think effectively concede, that the names on their own don't really tell you anything because there are so many qualifications that might be made as to what those people are doing. So we say that example doesn't establish that you can infer anything about a party's litigation strategy. And the second example, my learned friend, is, if I may put it, no more compelling. He gives an example of a company which deputes the handling of the litigation to its head of settlement. Now, quite apart from the fact we've never heard of such position and don't believe a company would have it, but even if a position like that did exist, it just isn't the case that identifying them as someone giving instructions or receiving advice would actually tell you something about Loreley's strategy or evidence gathering. And if there were a rare case where the person's job title gave something away, coming back to my Lord's point about concern about making a decision that goes too far, well, one could in that example explain, and with thanks to my junior Mr. Scher, for example, what about head of hopelessly artificial implied representation claims intended for quick and dirty settlement? Now, if there was such a position, the judge's view allows the party to put in evidence to explain that. In this case, that due to the very unusual and long title of the person, that giving that title would reveal something, and on that basis, privilege is claimed. But, as we know, we do not have any evidence of this sort in this case. My Lords, let me deal very briefly with the client identity cases. That was the second area of my submissions, and I'm not sure I really need to spend too much time on this.
I don't think you do really, but take it very quickly.
I will take it very quickly. All I'll say is my learned friend's position seems to be a bit of a muddle about whether they're relevant or whether they're not. Can I make the point about Abliazov and SRJ? I'm not going to take you back to them.
No.
Those are the cases he relies on because they were cases where the contact details in Abliazov and the identity in SRJ were held to be privileged. As my Lord Justice Mells already pointed out, in both those cases there was evidence before the court, and you, just for your reference, in Abliazov the evidence of Adelshaw Goddard is referred to at paragraphs 5 and 8, and in SRJ we've got very detailed evidence set out that in fact Mr. Justice Knowles set out in his judgment below. If you look at paragraphs 17 to 19 in SRJ, and Mr. Justice Sir David Eadie in that case made very clear in his conclusion that it was in the light of the evidence given by the solicitor in that case that he found that exceptionally the identity of the blogger was privileged. Now, can I make some very important contrasts with this case? There is no suggestion in this case that any individual giving instructions to RPC has at any time been seeking legal advice in relation to keeping their identity secret. Nor is there any suggestion, and I think this is a point that my friend laboured on Abliazov, there isn't a suggestion in this case that the identity of those communicating with RPC was something that was provided, the fact of their identity was provided confidentially and on the basis that it was to remain confidential. That is not, has never been part of my learned friend's case. So those cases on that basis are distinguishable. There is no such evidence as there was in those cases. My Lord, I won't take you to the other identity cases. You've got them referred to in our skeleton, but the ex parte Rogers case makes very clear, that's the decision of Chief Justice Bingham, makes my Lord's point that its privilege attaches to communications, but he also makes clear there that what is critical, the reason for his decision of finding no privilege in that case, was that the record of the time revealed nothing of the content of the privileged communication. So we're back to our secondary evidence concept. There was nothing that was revealed about the content of the privileged communication. Just to finish on these identity cases, my learned friend says that the judge's test is too uncertain a test for the purpose of deciding whether a matter is protected. We say that is a strange submission because actually in substance the judge's test involved the same analysis that the courts have performed in all these so-called identity cases in approaching the question whether identity or contact details are privileged. And we also say that the analysis in those cases can be understood simply as an application of that wider secondary evidence doctrine which applies to both limbs of privilege we've looked at. Would the material in question reveal, or would it allow one sufficiently to infer the content of the privileged communications? So the analysis as to whether here the identity might reveal something about the underlying privileged communication is exactly the same. And Loreley 30 cannot begin to justify some special rule for the identity of persons authorised to give instructions. Because I'm going to turn then now to my third set of submissions, which was about the implications, the problematical implications of Loreley 30's position. And there's a group of practical problematic implications, but there's one legal, which if I may deal with first, which will just take a slightly more time.
Well, you haven't got slightly more time.
Well, I think I have, my lord, until 10 past, because my learned friend finished 5 minutes.
Oh, we're finishing at 4:15.
Are we?
So that's not really fair, is it?
Well,
We'll take this as quickly as you can because really
I apologise for that, my lord. I think my learned friend set a proposed.
Yeah, madam, sorry. We thought it was 4:30. We didn't know we were stopping at 4:15.
we always
It's our
finish
fault.
at 4:15 in this court unless we say otherwise. And I can't sit very much beyond 4:15.
Well, I'll see if I can finish within 5 or 10 minutes.
Okay.
My lord. That's agreeable. I'll have to give. I won't be able to take you through it, but let me take you through. Give you the references. So, this legal consequence. I said at the outset that my learned friend's position means a different distinction, a distinction between the treatment of the identity of those authorised in the legal advice privilege and litigation privilege context. His appeal is premised on that different approach. And specifically, he has to say that lawyer-client communications concerning litigation are worthy of greater protection than lawyer-client communications which do not concern litigation. The reason he has to say that is because to claim legal advice privilege as he accepts, you would need to identify the person giving instructions. So that's why they have to make this distinction. They don't, however, ever justify it. Again, it's assertion in their skeleton. Well, I say not at all justified. They attempt to justify it, but we say it doesn't get off the ground. And they attempt to justify it by saying, well, there's a different treatment. The different treatment is justified because you have different rationales for the two limbs of legal professional privilege. And they say on that basis that the policy of litigation privilege means that the identity of relevant persons should be protected. But my lords, so far as lawyer-client communications are concerned, the rationale for protection is exactly the same in both cases. So there is no reason why litigation privilege should protect identity, but legal advice privilege should require it to be disclosed. And that's clear from 3 Rivers 6. And I won't take you through it, but if I may just give you the references and just set it out so that if you have time, I accept it's a bit more of a connoisseur's point. You'll recall that 3 Rivers 6 was about the scope of legal advice privilege, in particular whether assistance and advice of Freshfields as to how the bank should present evidence and material to the beginning of inquiry constituted legal advice for the purposes of legal advice privilege. The Court of Appeal said that material fell outside the scope of legal advice privilege. The Court of Appeal's position was conditioned by the acceptance of the proposition that had been made by BCCI that legal advice privilege was an outgrowth and extension of litigation privilege, and it was therefore concerned with legal rights and obligations which were capable of becoming the subject matter of litigation. And so that led to a narrower scope of legal advice privilege. And they had therefore, as a result of that finding, doubted the rationale for legal advice privilege outside litigation. Those issues were then all revisited by the House of Lords. And Lord Carswell's speech is the speech to read on this, but very briefly, following a full historical analysis, he concludes, rejecting the views expressed by the Court of Appeal, that the rationale behind the protection of lawyer-client communications is the same and equally strong whether or not the advice is sought in connection with litigation or something else. And if I just give you the references, at para 90...
it's so familiar. And it's in the skeletons insofar as it needs
well,
to be.
my lord, then I'll leave it there. We say that this idea that lawyer-client communication should be afforded more protection because of litigation.
I should have thought that you'd have already realised that the court's appetite for lack of orthodoxy is quite limited.
My lord, I'll take that and move on. You have the point in our skeletons. Can I then just finish with the other practical consequences? Again, we've mentioned them briefly. The first odd consequence is that where communications, as I said, are protected on my learned friend's case, we haven't contested it, by both legal advice privilege and litigation privilege, the very fact of claiming legal advice privilege over a communication would necessarily entail a waiver of litigation privilege because of the need to require to identify the person communicating with the lawyer to establish that they were authorised. That's the Three Rivers 5 point. And we say that's unprecedented. Loreley 30 cannot point to any other situation where in order to claim one subhead of privilege, you have to waive the other. And there are all sorts of problems we've identified in our skeleton about how would that waiver work, what would the scope, what happens when litigation is in anticipation at the outset of the instruction, isn't in anticipation at the outset, but then becomes. That's the first practical problem. The second is to do with the law on substantiating claims for litigation privilege. And other problems with unforeseen waiver, and I think it's a point my Lord Justice Mells picked up earlier about who gives the evidence on making a claim to litigation privilege. The Westminster and Dornoch point. In most cases, the person who needs to give the evidence about who created the document and what its purpose was in a litigation context, they are likely to be the person giving instructions to the lawyer. But on Loreley 30's case, they couldn't do that without waiving privilege. So we say that is bizarre and just provides another illustration of why the privilege is wrong. And finally, we say Loreley 30's case proves too much, and that further undermines the proposition that my learned friend is putting forward. Because applying the same logic that my learned friend deploys on this appeal, to argue that the identity of those instructing is privileged, other information and material would also be subject to litigation privilege, even though we know it to be the case that it is not. So if one thinks of some other documents and communications, we know Loreley 30 hasn't claimed privilege over the entire engagement letter because it's provided a redacted version. But applying my learned friend's logic, why isn't the entire engagement letter privileged on the basis that it constitutes the arrangements or the channel by which instructions are provided? We know, of course, that that isn't the position, and Loreley 30 accept that it's not the position that that whole letter is privileged. And what about funding documents? Again, apply my learned friend's documents. Why wouldn't all funding arrangements a party enters into be within the zone of privacy on the same basis? Again, we know from Excalibur and Re-Edwardian Group that those are not privileged. And again, looking back to WH Holdings, why wouldn't communications, apply my learned friend's logic concerning the commercial terms to offer to settle litigation, why wouldn't that be subject to litigation privilege on his case? And then finally, my lords, turning to the identity of individuals. Why is it that my learned friend says the identity of those instructing would reveal something about the strategy to the litigation, but not, for example, the identity of the lawyers or the identity of the funders. If Loreley, as Loreley claims, the forensic sensitivities and exigencies of the adversarial litigation process mean the identity of the person communicating with the lawyer is protected, why not also the identity of the lawyer? In fact, as I submitted below, there's a much more credible case that one could infer more about strategy of a litigant from which lawyers they use than who's doing the instructing. And the same logic would also apply to the identity of a litigation funder, because we know that different funders are known to have different appetites for funding litigation. But there is clear authority in Excalibur that identity of a litigation funder is not privileged. My lords, I hope that was not too much over 5 minutes, unless there's anything further I can assist you with.
Thank you very much, Mr. Lord.
Well, I'll be as quick as I can, of course. Your Lordship asked me this morning.
You're going to have to keep your voice up because you've got a helicopter to compete with.
This is not a very fair fight, but I'll try, my lord. Your Lordship asked me this morning about the specificity with which one has to identify a claim to privileged documents in disclosure, and we've sought to research that. Can Your Lordship look up the? Does the bench have white books there?
Yeah.
Can we go to please to page 1080 of volume 1 of the white book, please?
What's the?
It's 31. It's the notes at 31.10.3. I'm going to submit it on the strength of these notes, but this provides pretty much a complete answer in our favour for this appeal.
So CPR part 31.
31.10.3, and it's entitled Description - Privileged Documents. And I won't read it out, but I ask your lordships, please, and ladies, my lady, to read those 3 inches of text, because it's important.
Sorry. Which page was it?
1080, my lord, in volume 1.
Against all my principles.
I'm sure this won't set a precedent.
Yeah.
31.10.3.
Yeah. Yeah, where privilege is claimed for professional communications of a confidential character obtained for the purpose of getting legal advice, the claim for privilege is to be treated as itself a sufficient description of the communication.
And also, the names and the dates the makers don't need to be given, so it can be done in this general way. That's the practice set out there.
That comes out of Holland.
And that's, with respect, what we've done.
Well, except that it gives the example of correspondence between that, in brackets, defendant and his solicitors, whereas the hypothesis here is that the correspondence is not with the claimant, Loreley, but with somebody else.
The question is about the instructions going to Loreley's solicitor. That's the question. That is the subject of Mr. Justice Picken's order. That's what we're talking about. And that, with respect, is litigation instructions, is what this is all about. And the suggestion that might be criticised for not further evidencing this matter is we say plain, it's wrong and unfair. That would mean that in every single case where some sort of query could be raised of this sort, like Credit Suisse make, you would get into a whole lot of debate about how much had to be said about each and every instruction. That's the upshot of this appeal.
Okay, well, I think we take...
And that's very, 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 very important, because that drives into the heart of this question about evidence. Because there's no need for evidence, as my Lord Master of the Rolls explained. these are litigation instructions. You need evidence where there is a proper a question about, for example, whether litigation was contemplated, or about whether some other relevant, whether the dominant purpose was for litigation. But on this hypothesis, Mr. Justice Pickens' order proceeds upon the basis of interrogation of instructions to litigate to the litigation solicitor.
Well, if you're talking about a communication in which X writes to the solicitor giving instructions about what should happen in relation to the litigation, that's all you need to know.
And we say on this white book authority that has been adequately evidenced for present purposes. And according to these notes, you don't need to give the names of the makers of statements. The names of the makers.
No.
Because what this question really is, although it's generic, Your Lordship is right, my Lord Marshal is right, it really asks, well, look at every single individual instruction and give us every single maker.
Yes.
Albeit don't repeat the names if they're given 10, just say it once. That's really what this is about.
So why didn't you say that was totally illegitimate when the order was made?
It's totally illegitimate. We've got.
No, but why didn't you say
well,
that?
because again, with respect, that's somewhat unfair. Because I'll explain why as shortly as I can. In these sort of CMCs, this court has a more orderly and linear process.
We live in a rarefied atmosphere.
Well, I wouldn't begin to suggest that, my lord. But down in the sort of lower echelon,
The Knowles building, we call it.
Yeah, certainly where I was on that day, it was all rather harum scarum, my lord, shall we say? So one has to do the best one. The judges may want to move the whole thing case management-wise on. No,
what do we do, Mr. Lord? Sorry, I mean, you're pushing at an open door so far as I'm concerned, only for myself.
Well, what
do we do? Just let me ask you this question. If we think that this was a totally illegitimate order, but you haven't appealed it on the right grounds.
Well, but that is not the reason that is not a. This is you can't the former Justice Pickens. This matter.
You might want to stop and think what the answer to that question is.
I've thought about this because what this court can't do is to support or allow the further prosecution of an order that should not be made, should not have been made. But I don't accept criticism about appealing for this reason. We've got the transcript. I've got time to go to that. We'll give hard copies and we will send an electronic copy through to the bench. But the reason it is deeply unfair is that this point did not come on from a formal application notice. That was the insinuations in the submission. What happened in a deeply unsatisfactory way is that Credit Suisse submitted a draft order or agenda for this CMC, where this sort of order had come on to the agenda or draft order. There was an application notice for it. It was in that form. It was debated over some 80 pages or so of the transcript. Mr. Pickett, I did my best to say this isn't relevant. It goes to privilege. It's abstract. All the points that I made all those points, and he sat there. He sat there, and he made it really plain that he was troubled by the abstract nature of all this debate. Correct, but what he was minded to do was to push on us to, if you like, to bring some more information forward. And I think a fair reading of that is, and then the court would look at it again, and privilege would be open to be taken. That's a fair reading of why we ultimately didn't agree, but we backed off in that CMC way. So we want to make a big fight about it. We didn't want to go to the Court of Appeal at that stage on that rather fluffy, fuzzy basis. We thought, right, we'll regroup, we'll set our stall out, and that is why it's Mr. Justice Knowles' ruling that is really the key order here. The key consummation, crystallisation of an order that should not have been made ever, we say, and should definitely be set aside now on appeal. And that doesn't
If you're going to give us those hard copies or electronic copies, can you please identify what you say are the critical
Certainly,
pages?
my lord.
I mean, if we have to read the whole 80 pages, then I suppose we do, but it would be helpful.
We will sideline it. What we'll do,
critical.
We'll give you the references, and we will sideline it. You'll see in the way of these rather the CMCs that the debate sort of bobs around, and there's interruptions and so on. So we say that it's not right to say that we're foreclosed from saying it's a bonkers order. It should never be made and should be quashed on this appeal court hearing. Absolutely. No.
Bonkers.
We say that it really ought that's the right approach, because it was Mr. Justice Knowles. It was that application that reflected in his order that really gives this the sort of teeth. And you'll see it from the transcript. So
but perhaps if you're going to sideline the bits you say are critical, Ms. Oppenheimer should also have the opportunity. Hopefully that won't result in the whole lot being sidelined, but really the critical points which both parties rely on.
Yeah, well, we will submit one with highlight, with maybe different colours, but one composite. We'll do one composite version, and we'll submit it as soon as we can to my lord and my lady.
I hesitate to get up. Can I just voice my concern? I know I've had my time. This has not been a point that my learned friends have raised, and this has been going on for well over a year. I'm very concerned that the suggestion that this order should now be appealed on a different basis, which has never been the basis on which this case has been put forward.
I'm dealing with
the
the
order
order
from the bench.
is juridically unsound. Miss Oppenheimer, sorry, excuse me.
Sorry, my lord.
What if the order is juridically unsound and could never have been made by a judge properly?
My lord, we haven't had an opportunity to address that point. Has been put to me during the course of oral submissions. We've not had an opportunity to put a case on that. If your lordships are considering making a finding about that, then my submission, we should have an opportunity to make submissions on that point. It's never been put. This case is both parties have been proceeding.
You can make them in writing. Both sides.
And then just very, very quickly now, this is not a secondary evidence case. We're talking about litigation instructions. There's no need to carry out some inferential exercise to work out, is legal advice somewhere else being betrayed here? We know the communication. It's a litigation instruction. We know what's being withheld, the name of the giver of it, consistent with the White Book description, but we say that communication is privileged, is adequately described per the White Book, and that's the end of the matter. And to go any further than that, we say does involve interrogating privileged documents properly so claimed for. Secondary evidence is not engaged in the debate about clues. Secondary evidence is about whether or not another document betrays legal advice. It's not about what clues you might get out of looking into a privileged communication.
Lyle and Kennedy said it was, but just answer this for me, Mr. Lord. Let's assume that the order that the judge made were to be held by this court to be obviously correct but totally irrelevant. So the identities of individuals are not the subject of legal professional privilege because identities of individuals are not the subject of professional legal privilege. Do you say that's something we can't say?
Well, my lord, the order shouldn't have been made because what the judge did was to order a declaration, sort of at large. He made a declaration, if you like, sort of in the abstract, that then has to go off and be applied to documents. The fact that order was made following the Mr. Justice Picken exchange and this hearing, Mr. Justice Knowles, that doesn't mean that this court shouldn't set all that aside, because the right analysis is we have claimed privilege to documents properly. There is no basis to challenge that claim to privilege. No basis to open it up to get into the West Tankers type analysis. That's the end of that of any question of interrogating further the documents here. And we said that that's a complete answer to this point. This sort of abstract declaration as to privilege or not and what should happen was wrong. We tried to resist it. We tried for Mr. Knowles to resist it, and it should be resisted now. We say, and that there are just two other things. The witness identity cases, they're not about secondary evidence. The China National analysis is not about secondary evidence. It's saying that the communicator is part of the communication, and that seems to be consistent with the 31.10.3 White Book approach to claiming privilege, legal professional privilege. So the witness identity analysis of Andrew Morritt seems to be consistent with the way the White Book authors and commentators seem to think that parties will behave in English litigation. Just very, very quickly, funding is different. Funding is not the same as litigation instructions to your litigation solicitor. Email exchanges amongst directors is not the same as litigation instructions to your solicitors. Those are paradigmatically privileged communications, and somehow the bank has burrowed into this unsatisfactory pre-trial process. It's burrowed into things that in the ordinary course it would never have been allowed to burrow into. We say irrelevant, go nowhere. The bank stops at this stage for fear of going on to reveal that it is trying to get into the box, and we say and we respectfully submit that the appeal should be allowed. And my dear friend said that when the client identity is wrapped up with a privileged communication, I think she was suggesting that would mean that you could claim privilege. Well, the client ID is wrapped up with a privileged communication because it's part and parcel of it, and we are not obliged to put a name on each document in the disclosure requirements, and therefore that guidance in fact informs the sort of answer to this global generic interrogation that we've been trying to see off since Mr. Justice Knowles' order. Sorry, my lord, I had to go very quickly, but I was conscious of the 4:15 stop.
Yes.
Can we help further in terms of any further
further submissions? I mean, I don't want anybody to feel when they get judgments in this case that they've been shortchanged or bounced because in the course of a one-day appeal, naturally things crop up.
Yes.
Maybe not at the beginning, but in the middle, when people think of things. It's the nature of litigation. Does anybody want to make some more considered submissions in 3 pages about paragraph 1 of the order? Yes?
We would like the opportunity to do something.
Would you like to?
Yes, please, my lord, if your lordship's prepared to indulge us. Yes.
We would be. You can sleep on it and perhaps think a little about what's happened. You'll even have a transcript of it. And if you want to do that, I suggest each of you do that by, say, Monday night. Is that all right? I don't think we should be responsive, do you? You've both heard. You're both giving your views.
Could we have perhaps until Tuesday night?
Yes.
No.
Looks like I should be in Australia next week, so it won't matter to me whether it's Monday or Tuesday night. It'll be morning for me. Tuesday night it is. That is 6 o'clock, say, on Tuesday night.
Thank you, my lord.
Anybody want liberty to do anything else? You're going to give us the transcript sidelines.
We will do that. And I think we'll have to make some cross-references in our little 3-page note.
So it may as well be at the same time.
In the same
even
point.
if it's a bit late. And you're going to give us. Were you going to give us the application or the what Mr. Justice Pickham was deciding?
We can do that, my lord. We can agree a bundle of the Pick-and-J papers if that would help on that point.
It may be useful to have the skeletons, for example.
Fine.
Yes, fine. The skeletons would probably be helpful. Thank you.
My lord, I don't have any other point on that, save to say that we did a bit of work as well on this point about the practice of listing documents. We've got a section of Thankey and the decision of Chief Master March in Aztecs Therapeutics. So the basic position is, although there's obviously the Part 31 position and then there's practice Direction 51U, no longer 51U, now 57AB. Under Part 31, I think the point that comes out of the Chief Master Marsh decision in Aztecs is that whilst the rule is that you're meant to list out everything individual, everyone recognises the practice is you don't, and I think that's an observation that is made, is the practice is that generally people have listed, litigants have listed in categories. However, and this is a point that comes out of the Thankey extract, I think where the law now lies, leave to one side for the moment, the new practice direction, is that the normal practice is not to list out individually, but there is a discretion for a judge in an appropriate case to say, actually, in this case, I want them listed out individually, and there may be, in a fraud case or something, it may be necessary. So there's that whilst the practice is still the one that we are all familiar with of listing out in categories, there is an ability for the court to order out listing out individually.
And do you disagree with the accuracy of note 31.10.3?
I don't disagree. I just would like to make the distinction that there's obviously the process of making your claim to privilege in a list, which will say very little, and then what happens if someone challenges your claim to privilege, in which case we're obviously in the territory of all the cases on the evidence you need to put forward. And I felt at points that my learned friend was slightly eliding the two. There's the practice that you need to do to list and make your claim. If the other party says, right, you now need to justify that, then you're going to have to do a lot more. And you can't just say, it's in the list.
But just to be honest, the practice direction on the disclosure pilot, that's 51U, paragraph 14.1, at page 1804 of the White Book, volume 1. That also says this: a claim to privilege may, unless the court orders otherwise, in brackets, be made in a form that treats privileged documents as a class, provided always that paragraph 33.25 is complied with. That is that I think the solicitor, somebody confirms that they've done a proper, to undertake a review to satisfy themselves any claim is properly made, and the reason for privilege sufficiently explained. So we say that the position is for a litigation instruction, you wouldn't get beyond the material that we've already put in play. The fact that we're now debating what clues, what might lie behind all this, is because through Mr. Justice Pickett and Mrs. Knowles, we have moved unusually, uniquely, way down the path, further down the path than we should ever have travelled had it been done in an orderly way, based upon documents and so on, communications, in my submission. But we'll set that out in our note.
Thank you. There is a 4-page maximum limit on these notes. If they are longer, they will be thrown in the bin, not just cut off at page 4. That is enough.
Okay, that one. Should we send?
Yes, please.
Should we send it all electronically?
And hard copies to my lady and my lord. Yes.
Thank you, Madam.
Thank you all. What an interesting day. We will take time to consider our judgments. When we hand them down, we'll send them to counsel and solicitors notified to the court in the way now established. It's up to you to decide which clients need to see them for the purposes set out in Counsel General for Wales. If nobody it should be, and you should agree the order and any determinations to costs, and if you can't, we'll deal with that in writing. There will be no further oral argument. Thank you.
Well,